participate in those proceedings. Thank you.
Mr. The parties, are you opposing the possible consolidation?
Yes, my lord, we are vehemently opposed, my lord, to the joinder or intended consolidation of this petition, and but also that we don't take time before you this evening. We would prefer, my lord, that this matter also takes the cue of being mentioned tomorrow with the others, my lord, where we will substantively, my lord, be presenting, my lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my lord, so that we save time, I speak for all the respondents.
Mention tomorrow.
Sorry, my lord.
Mention tomorrow.
We mentioned tomorrow.
My lord, if you permit me. My lord, there is a mischief that we need to cure or to safeguard ourselves against. My lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
Since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my lord, because the question of consolidation is a question of law, and it's purely on a principle question. And my lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you. Yes, please. My lord, my lord and my lady. Yes, I am guided by my senior counsel, Paul Mwite. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo moto, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitioners.
The court has spoken. We'll mention it tomorrow. Thank you. Let's consider that tomorrow.
Most of that.
This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerated are appearing for the petition, the Deputy President, in this matter.
Yes.
Yes, my lord, for the respondents, a quorum similar, my lord, so that we save on time. My lord, we will be willing, my lord, to present before for 2 options. Either, my lord, we retain the mentioned date that has been given, or, my lord, you mention the matter tomorrow, so that if there is anybody who want to address you, they address you tomorrow, my lord.
We don't want to talk tomorrow with so many matters. If there's no need, we can retain the 29th.
You can retain the 29th.
We can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, no, you have not mentioned my matter.
Which one?
509. 509.
It was consolidated with five.
Sorry, I'm sorry, I never had you call it out. I'm sorry, Mr. Kid was keeping me busy giving me. My lord, in that respect, we have an application. The lordship, I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court or by the court referring the matter to this court.
Well, I believe this is the matter that we have earlier indicated, that after all these matters have been consolidated, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out three things. Number one is that we will need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number one. Issue number two, my lord, that is important, is the fact that now that today the Honorable the Chief Justice has forced all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or otherwise. Thirdly, my lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told, we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Your Lordship.
Yeah, Your Lordship, there is
You can see that we are consolidated.
Now we will proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues. But importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue of consolidation. That one we will give direction on that. So that is the way forward. Prepare to hear the application for recusal of the bench tomorrow at 2 p.m. In the morning, we will deal with the procedural issues of consolidation and any other issue which may arise in cohort 1 and cohort 2. Thank you.
And those are very clear directions by the leadership. And we entirely agree that we will assist in the orderly progression of the hearing of this case. Thank you.
Just for the record, my lord, we assume it is all the 3 applications for recusal because they are.
There will be no other application for recusal. We will hear what is on record, and it will be, a ruling will be delivered. There will be no other application for recusal. And we think that that should come first, because if you don't want a bench, there's no reason why we should do any other
Fair
thing.
enough, my lord, I was only pointing there are 2 or 3 of them.
Yes.
And the only clarity I'm asking is whether all applications for recusal we have together.
Yes, together, all will be handled together.
Yes.
Your Lordship, finally, as you categorize these pleadings in cohort 1 and cohort 2, I kindly allow me to remind the court that the last time we were before you on the 16th, the court gave or granted leave for parties to amend their petitions. So there could be petitions that have now crossed over to cohort 2, pursuant the amendments bringing in light the transpired. Perhaps the pleadings will bear witness.
Mr. Nego, those are some of the preliminary issues which we'll deal with in the morning. But principally, prepare to argue your application for refusal at 2:30.
I am ready
But
even now.
before we break, with your very kind permission, and we've done this, I would like to put the deponents of the affidavits that have made very, very grave allegations about judges of this court to be present tomorrow at 2:30, because we reserve the right to cross-examine those deponents and to move the court as appropriate after that.
Well, perhaps if I may request that the court supplies us with a typed copy of the ruling that you have delivered today. We know you are working under very tight timelines, but we would very much appreciate a typed copy of the ruling that you have delivered today. We believe it may be useful in the tasks at hand tomorrow.
Thank you, Your Lordship. These are ruling that you delivered on 16th of October in the consolidated petition 522. I believe you can get a copy of that ruling as well.
The ruling should be available.
So, yes, finally, my judges, I think there is a law about service, that there are some parties who are present and have not been served, and we've been hearing this from inception. I think tomorrow we settle the issue of service. We also settle the issue of filing of any affidavit or responses that ought to be done, so that after 2:30, we know how best we're going to proceed without people intervening with, I have not had sufficient time to this or that.
And I think before my presiding judge addresses, I just want to remind parties that we are using technology to move. To me, the issue of service should not be a big thing, because if you are marked into a matter, automatically you get everything, unless you are not in the system. And if you are not in the system, get in touch with the deputy registrar. As simple as that. So that we avoid these issues of I was not served, I was served, I was not served. Let us make use of the technology at hand. Thank you.
Can I suggest that, Lord, we are appearing tomorrow in the ceremonial hall at 11. I was going to plead that any other issues being raised from the bar be raised tomorrow at 11. No.
My Lord, as the chair in charge of all the people who are retiring, as they can vote at this particular moment, all the people who are present.
Next session.
Just to avoid any doubt, the application for recusal will be heard at 2:30. Whether you have responded to it or not, we will hear it. We will not allow any adjournment on it.
At what time tomorrow morning, sir? Because some of us did get there.
Tomorrow morning at 9.
At 9, yes.
Yes.
And we're going to 11. It's at 10 o'clock.
We're most obliged, my lord. We can see you for
clarification, physical or you can
Mike yangu iko pale. Pita chini.
I think that concludes our sitting today. That concludes our sitting today. See you tomorrow.
Yangu iko pale mbele.
The reason why Nairobi has not opened another file to put together all the files from Kirugoya is this. Going by the orders which were issued by Kirugoya Court, there was a specific order that because of the transmission, parties will still file their documents under the Kirugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we will now raise the issues that we want to raise, particularly arising from the issues in Kirugoya. And I do not
We will then
know.
proceed and take forum on it. They were consolidated, so we will not take further forum on this matter.
The Attorney General, I don't know, I had indicated to the court earlier, I need to raise some clarifications.
Section
Unless
7 of the Attorney General's Act.
You had read your subject to speak. It doesn't override my right to represent my clients.
I'm repeating.
Can she then say her piece, I say mine?
Now, which matter are we now dealing with?
We have 0115.
We have several.
We have 0115.
My Lord, I wanted to say that
Yes.
the only matters before this court are the matters which had ex parte orders. The matters that came from Kirugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders.
I think they do.
We have E15
E15 has
conservatory orders, but E13 and E14, although from Balindiway, they were filed before impeachment and they had no conservatory orders.
I hope I have then been heard without further interferences. My Lord,
Which is the matter, Mr. Paybill?
my Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kirugoya 15.
Yes, Kirugoya 15.
Kirugoya 15, yes.
Yes. My Lord, the clarification that I seek to raise
emanates against this general background. The first one, my lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit, in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice Mwini, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may
I think I have a right to raise those issues. I have a right to respond.
Just give we have fellow Mungai time.
Mungai, Muigai.
I just wanted for good order, my Lord.
Is that a clarification, Mungai?
My Lord, I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. But under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lords, under the former constitution, My Lord, under the former constitution, we used to have a practice in which we had an officiary, a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. My Lord, because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my Lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
You apply that we discharge the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Chief Justice, Deputy Chief Justice. That's what we are indicating. My Lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue we speak for the wananchi and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state? And it used to happen those days before we had a new constitution. Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable...
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that then does not have to do with those prayers. My Lord, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is a right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So what, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lord, sir, just to add on what my learned friend has submitted on, I feel...
With the permission of the presiding, I wish to say, I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters, I can assure you. There is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
But allow us to worry when we have grounds.
Senator Muche and Council Negua, you know, when you argue the way Mr. Mbe has argued, that court start on Saturday, you are arguing on both sides of, because you know that we work online. And most of you know that matters reach us anytime, at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that call on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Murai. Let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't finished. We have not finished. E015 in the report. The deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ugoya will be making submission. But my Lord, do give us this very weighty matter. This E015 in Kirogoya. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give that permit us to articulate these issues for the sake of the nation? We are not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There is no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench to hear these 3 specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empanelment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 plus 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the root of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's where the constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why this should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the fifth respondent in Israel 15. I believe the reason we are here and the reason why we took quorum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the rulings of the court. So in this regard, my proposal is as follows, that each of the parties whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectively urge that we get an opportunity for each of the parties to ventilate the issues, because the fifth respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the termination of a presidential over deputy president, which in our view lies squarely within the domain of the Supreme Court. So we want accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
For the fifth interest, for the first interested party.
Mr. Lawyer, just a minute. I was about to interject when when counsel, Mr. not the other one. Yes, Mr. was addressing. And that is exactly why I wanted to. I wanted us to have order and the way we conduct this proceeding. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which...
The application can only come after I have spoken.
We are now making an application, you respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 546. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations. I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes,
my lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and Ndegwa and my friend Kibe, is that you are taking the court for a long ride and you're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's stand. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Andrew Mohi. I am acting in person. We filed an application for the certificate of urgency on the 8th of October, 2024. Before this bench was impaneled on the 14th of October, 2024. Unfortunately, some of the records we were seeking have been overtaken by events. My lord, and today, as we have heard, our application has not been placed before you, and we are just concerned that our application will once again overtake our application. My lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, may I just be heard for 1 minute only. My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Grima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that suit, in accordance with my teacher's guide and Professor Balindiway, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is Mr. Boy applying for an adjournment? Because he's saying, and perhaps wrongly, that even the recusal application comes after the termination of the question on panelment. If that be so, and they may leave, they normally leave court, they left Senate, may leave court. We let them say whether they are applying for adjournment.
Is that remark, they normally leave court where the left Senate, palatable in this court, my lord? I need that.
No, because it's an adjournment.
No, is that remark palatable for my lords and my lady? But because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a vain application for adjournment. Because Mr. Wara is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I answered your question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but he did withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem with withdrawing. Okay, my friend, no, I have no problem, my lord. I withdraw the remark, but
Thank you.
there is practice.
Thank you. Let me now address the question. My lord, Professor Agenda was my teacher and my mentor for many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Kive Mungai, and learned colleague, Mr. Ndegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Balindiway again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and this, or should have, they would have found out. The letter, which was written this morning, which we have, it was received on the 20th, the 20th of October, as actually one pertinent question disposed whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and then possibly the only reason we should be given is why the file was taken to PCJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. But as we do in the Parliament, you go around in circles to waste time so that the motion
possibly is defeated by a fruition of time, which is what they're trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add.
This court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application. before